Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
We've already lost more than 13,000 Americans to gun deaths so far this year.
An independent analysis of financial harm to the firearms industry from the pistol brace ban has been estimated to exceed.
Every day, more than 100 people in America die from gun violence, and many more.
In one of the instances challenging California's ban on so-called assault weapons, several significant developments have occurred. The impact of recent Supreme Court decisions on gun control laws. The 199th mass slaying in American history has ignited a discussion about the right to keep and bear guns and the authority of the government to enact limitations. Providing a broad reading of the Second Amendment of the Constitution, which serves as a foundation for gun rights in the U.S., the Supreme Court's ruling from last June restricted legislators' authority to impose restrictions on the possession of firearms in public. An explosion in court challenges has resulted from this decision, claims Nick Suplina, Senior Vice President of Law and Policy at Everytown for Gun Safety, a group that advocates for tougher gun control. With the decision in New York State Rifle and Pistol Association v. Bruen, which was predicated on District of Columbia v. Heller from 2008, the current age of legal turbulence came to an end. The decision established that, contrary to what the Second Amendment claims, participation in a militia is not a prerequisite for a citizen's right to keep and bear weapons. In the Bruen case, a New York law that required gun owners to demonstrate that they had a specific need to carry a firearm in public was explicitly contested. According to the court, carrying a gun is a constitutionally protected right that extends outside of the home, making the New York legislation illegal. The majority opinion was written by conservative Supreme Court Justice Clarence Thomas, who demanded that any future gun restrictions meet two requirements. First, the weapon in question must be protected by the Second Amendment, and second, the government must justify any restrictions on the right to bear arms by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Measures to restrict the use of firearms have been notably disrupted by this second item. Lawyers are scouring centuries-old English and U.S. laws for analogous restrictions on weapons in response to the verdict. Advocates have cited prohibitions on billy clubs and other unusual weapons, as well as racial legislation, as evidence that the U.S. has historically prohibited certain groups from owning firearms, such as free black people, Native American organizations, and Catholics, as well as other groups deemed dangerous. The Supreme Court ruled that historical laws must now be presented that date from the late 1700s, or perhaps even the 1800s, in order to support the validity of a modern gun law. The government, litigants, and courts are wrestling with how to apply historical legislation from an era with significantly different issues and technological advancements to the present. Jacob Charles' study revealed that in the 8 months after the Supreme Court's Bruen decision,
Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights. 40 million firearms with stabilizing braces currently in circulation. Under the new rule, these firearm owners will be required to obtain special registration. An independent analysis of financial harm to the firearms industry from the pistol brace ban has been estimated to exceed
212 lawsuits challenging pre-existing gun restrictions had been decided in courts all around the U.S. At least 31 of the allegations were upheld by the courts in a challenger's favor, including successful challenges to license to carry laws, limits on assault weapons, and restrictions on allegedly untraceable ghost guns. In an urgent request to the Supreme Court, pro-gun organizations invoked the Bruen decision in an effort to overturn Illinois' recent legislation outlawing assault-style rifles and high-capacity mags. The outcome of the lawsuit, if it is heard by the conservative-dominated Supreme Court, might have significant repercussions for future restrictions on certain things. Disputes surrounding a Fifth Circuit District Court decision from February that invalidated a federal law that forbade those under protection orders who were accused of domestic abuse from owning firearms. President Joe Biden's administration has asked the Supreme Court to hear the case, which goes against numerous earlier judgments, but the High Court's justices have not yet indicated whether they will. Domestic violence survivors are a danger because of the current level of ambiguity. Data from the hotline revealed a 56.6% increase in calls mentioning firearms between February 2 and March 9 in the states covered by the Fifth Circuit Court, compared to the same time period previous year. It has also been demonstrated that domestic violence contributes disproportionately to mass slayings. According to a 2021 study, domestic abuse was a factor in almost 60% of slayings between 2014 and 2019 that resulted in the ending of 4 or more victims. Since the Bruen decision by the Supreme Court, there has been judicial strife, with federal courts all around the country issuing different decisions on other gun control legislation. Other gun control measures have been the subject of varying decisions from federal courts across the nation, including age restrictions for carrying firearms, a ban that would prevent those who have been charged with a crime from purchasing a firearm, limitations on high-capacity mags, and a law that would outlaw owning weapons with altered serial numbers. Since the Supreme Court's Bruen decision, there has been judicial strife as lawmakers in numerous states have advanced ambitious reforms. Suplina from Everytown claimed that lawmakers haven't been chilled into inaction in major part, and that many gun control laws will remain in place in the wake of the decision. Impact of Miller v. Bonta on Washington's assault weapons ban. For the benefit of those who are unaware, Judge Benitez's decision in the case of Miller v. Bonta, which is the assault weapons prohibition case in California, will really have any impact on the new assault weapons ban that has been implemented in the state of Washington. According to Section 30515 of the California Penal Code, the state of California prohibits various categories of weapons based on the features of such firearms. For instance, a semi-auto center-fire rifle that has a detachable mag is not allowed to have accessories such as a flash hider, a collapsible stock, or a forward vertical grip. If it does, the rifle is considered to be an assault weapon. This prohibition is being put to the test by Bolton. The preliminary hearing for the Miller case was held in the Southern District of California, and it was presided over by Judge Roger T. Benitez, who is also known as Saint Benitez in the state of California. After a first examination of the case, Judge Benitez came to the conclusion that it involved an average gun case involving an average shooter, employing an average strategy in order to accomplish an average result. After Judge Benitez overturned the ban on assault weapons in California, the state of California made the decision to appeal that decision all the way to the Ninth Circuit, which is ultimately where the Miller case sat since there was a backlog of cases waiting for the Supreme Court to rule in the end. The Miller case was finally seated there. While we waited in California, another state in the Ninth Circuit, the state of Washington, went ahead and established their own version of a ban on assault weapons.
We've already lost more than 13,000 Americans to gun deaths so far this year. We are the only nation in the industrialized world that tolerates such gruesome statistics.
By some counts, so far this year, there have already been 174 mass shootings. Every day, more than 100 people in America die from gun violence, and many more.
This prohibition was passed while we were still waiting in California. Some of the language that was used in the ban enacted by the state of California was taken and used by the state of Washington. This case, along with a number of other Second Amendment matters, was sent back down to the lower courts, including Judge Benitez, so that he might reevaluate all of these cases in light of the recent ruling made by the Supreme Court. A similar express list of vehicle makes and models that are banned by the state of California may be found in the state of California. Here in the bill that Washington passed, there is expressly named 65 firearms that will now be considered to be what are commonly referred to as assault weapons. The state of Washington added a catch-all clause that says anything like an AR-15 or similar to numerous of these laws. The clause may be found in several of these sections. The genuine prohibition on the possession of firearms will take effect. The law in California was altered by Washington to make it far more inclusive. As a direct result of the incorporation of a characteristics ban into the Washington bill, the state of California even went so far as to criminalize fin grips. Any muzzle device, such as a muzzle brake or compensator, any forward grip, such as an angled grip or a hand stop, and any threaded barrels are all included in this category. Additionally, Washington went ahead and targeted the purchase and selling of conversion kits as well as individual parts. According to the measure, so-called assault weapons can even be described as individual components, combination parts, conversion kits, or even just individual parts in the state of Washington. As can be seen, the California prohibition on assault weapons and the current ban in Washington share certain parallels. However, Washington has also included some extra provisions in their ban. Many individuals are of the opinion that Judge Benitez's judgment in the case of Miller versus Bonta will ultimately result in the repeal of the ban in the state of Washington. However, I want to point out some reasons why this may not be totally true and guide you through why the Miller case, while important and prominent, may not automatically overturn the Washington restriction on carrying concealed weapons in public places. In the first place, the Miller case directly challenges only a single part of the assault weapons restriction in California. The restriction on certain qualities and a list of prohibited makes and models are the two primary components of any rule. In the Miller case, the focus is on the features ban that can be found in Section 30515 of the California Penal Code. Another case, known as the Rupp case, takes a more comprehensive approach and challenges both the Roberti-Roos list, makes and models list, and the characteristics prohibition. This case is also known as the case in which the defendants were sued. Therefore, even if Miller is granted a positive verdict, this will only have an effect on the features prohibition in the particular combinations that are stated in the California legislation. This is the best case situation. In addition, it is essential to have a solid understanding that the Miller case is now being heard in the Federal District Court for the Southern District of California, which is located in the state of California. Although the federal courts in California and Washington are both under the jurisdiction of the Ninth Circuit, the decisions made by one district court are not binding on the decisions made by the other. In most cases, the views handed down by one district court are not binding on the decisions handed down by any other district courts or courts of appeals. For instance, numerous courts of appeals, such as the Seventh Circuit, have ruled that the decision of a single district court has no impact on the president and does not constrain the decisions of other district court judges within the same district. Therefore, despite the fact that the Miller case can present a compelling argument for the cause of the Second Amendment, it does not automatically bind other district court judges, particularly in other states like Washington. In the event that a case with comparable circumstances is brought before a federal district court judge in Washington, the result of the case may be contingent on that judge. They are free to make their own judgment based on how they understand the law, even if they are allowed to take into consideration the decision that Judge Benitez made, but they are not required to do so. In conclusion, although the Miller case may have an impact on Second Amendment cases in Washington and other states, this does not necessarily mean that the ban on handgun possession in Washington will be overturned completely. The terrain of the law is difficult to navigate, and the results of individual cases will be determined by the particular facts, arguments, and judicial decisions in each jurisdiction. The complex path of legal impact. This discussion delves into the complexities of how a federal court decision, such as Judge Benitez's ruling in the Miller versus Bonta case, may impact state-level legal disputes, specifically examining its potential effect on Washington's assault weapons ban. State court independence. In legal disputes within Washington's state court system, judges have even more autonomy and are less bound by federal court rulings. A decision made by a federal court in the Miller case, situated in the Southern District of California, holds less sway in state-level matters. Path to widespread impact. For the Miller case to exert a broader influence, it must ascend to the United Circuit, where a 3-judge panel or an en banc panel would deliberate on its implications. If this panel ruled favorably, it would obligate all federal court operating within the Ninth Circuit's jurisdiction to adhere to the decision. Partial impact in Washington. While a favorable ruling in Miller would undoubtedly benefit Washington and its assault weapons ban, it's crucial to recognize that Judge Benitez's decision alone cannot completely nullify the ongoing situation in the state of Washington. Furthermore, it doesn't eliminate all aspects of California's assault weapons ban. Pending Ninth Circuit decision. As of the present moment, the prospect of a Ninth Circuit decision on this matter remains distant, primarily because we are still awaiting Judge Benitez to issue his ruling. The legal process is multifaceted, and the trajectory and consequences of each case hinge on various factors, including legal jurisdiction and the specific nuances of the issues at hand.
The handgun to be the quintessential self-defense weapon
in the United States, and that is not what the Democrats are attempting to ban today, because that's already banned.
Gives private citizens the right to possess a firearm.
California assault weapons ban and legal challenges. Miller v. Bonta is a case that challenges the ban that the state of California has placed on the possession of so-called assault weapons. For those of you who are unaware, this is the case. We have some news in a different case, the Rupp case, that will probably have an impact on the Miller case and possibly other cases moving forward. Many of you are aware that the case is currently pending and waiting for the decision of Judge Robert T. Benitez in the Southern District of California. However, we also have some news in another case that pertains to the Miller case. The state of California has devised a policy that prohibits not just a certain list of brands and models of firearms, but also those that possess a specific collection of features. This policy also applies to certain types of firearms. According to Section 30510 of the California Penal Code, a variety of firearms, including the Colt AR-15, Steyr AUGs, Uzis, and other versions, are not allowed to be owned since they are considered to be assault weapons. If a certain firearm is located on this list, also known as the Roberti-Roos list, which is outlined in Section 30510 of the California Penal Code, that firearm is deemed to be illegal to own in the state of California since it is classified as an assault weapon.
You are issued weapons that allow for fully automatic and 3-round bursts. That is not available for purchase.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
Every time I depress the trigger, a round comes out of the firearm.
However, California, being the anti-gun state that it is, never stops at just one defeat. So after the first Category 1 list that acts as a model list, they then moved on to another assault weapons ban and added some text. This is because California never stops at just one defeat. You can find text similar to this in Section 30515 of the California Penal Code, a list of particular types of firearms with specific features that the state of California regards to be assault weapons, can be found in California Penal Code 30515. This list may be found in California. A semi-auto center fire rifle with a detachable mag and any other offending features, such as a flash hider, a pistol grip, collapsible stocks, a forward pistol grip, or any other characteristics on that type of firearm, make that firearm to be considered an assault weapon, and as a result, banned in the Miller case. Another example is a forward pistol grip.
It ruled that the state's ban on assault weapons is constitutional. The justices ruled 4-3.
The functionality between that weapon and this weapon are exactly identical.
From another federal judge striking down California's bans on assault weapons and large-capacity magazines.
On a semi-auto center fire rifle with a forward pistol grip. But Rupp is also a challenge to the list compiled by Roberti and Ross for Category 1, and since this results in the creation of a models list, we can say that this is a far more comprehensive and exhaustive challenge. Rob v. Bonta was brought before a court in the Central District of California, who heard all sides of the case, but ultimately ruled in favor of the state of California. This verdict was then appealed all the way up to the United Circuit, where it was presented for review before a panel consisting of 3 judges. In October of 2020, a 3-judge panel in the Ninth Circuit heard additional arguments on this challenging case. However, the case was then put on hold because the decision of the Supreme Court regarding the New York State Rifle and Pistol Association was still pending. Miller is a challenge to the prohibition on assault weapons in the state of California. Nevertheless, it only challenges Penal Code 30515 and the entirety of the characteristics restriction. When both of these cases eventually made it to the United Circuit, Rupp was put in front of Miller because it was first in line and because it involved a more comprehensive challenge to the laws of California. Miller was initially decided on by Judge Roger T. Benitez in the Southern District of California, but when both of these cases eventually made it to the United Circuit, Rupp was put in front of Miller. Legal developments and summary judgment hearings. Both the Miller and the Rupp cases have been sent back to the district courts in where they were originally filed in order to await Judge Benitez's rulings. A hearing on a move for summary judgment is scheduled to take place on September 9 in the District C regarding the case involving Rusty Bolton. Recent reports have shed light on a new key aspect of this issue. In addition, In response to a recent court order issued by the judge, a fresh hearing on the application for summary judgment in the case of Rupp has been planned. This indicates that a hearing for a summary judgment is going to take place very soon, which could have significant repercussions. The brief that the plaintiffs in these cases have prepared in support of their petition for summary judgment has been submitted. They highlight the recent reaffirmation by the Supreme Court that modern gun control measures must be able to bear scrutiny under the Second Amendment based on the government's capacity to prove alignment with the historical tradition of the nation. This is something that they underline in their brief.
The Second Amendment to the United States Constitution, Mr. President, as you well know,
Banning a class of weapons that you don't like the look of.
that's not a right of government. That's a right that each of us has as Americans.
In addition, the Supreme Court emphasized that there has never been a precedent for the prohibition of weapons that are normally possessed for authorized purposes. The state of California has made a courageous move by prohibiting, to a large extent, the purchase and possession of certain firearms that are classified as assault weapons. This includes guns that rank among the most popular in the country and that are held by millions of law-abiding residents as private property. The plaintiffs contend that there is abundant evidence to support their position that this ban should not be upheld. They argue that the court ought to rule in favor of the plaintiffs and issue summary judgment so as to protect the rights of all law-abiding adults in the state of California to have access to the firearms that are prohibited. The crux of their case is that California has not been able to demonstrate a historical tradition of banning these commonly owned weapons, and that the state's restriction of these rifles violates the rights guaranteed by the Second Amendment. In addition, the plaintiffs argue that a state cannot criminalize an entire category of firearms, particularly given the fact that the vast majority of legally owned firearms are kept in the hands of responsible gun owners. The reality of the situation does not align with California's aim to outlaw a particular category of lethal and uncommon weapons, which have been illegal in the country for a very long time and are not typically owned for legitimate purposes by law-abiding Americans. The reality of the situation does not align with California's intention to ban this category. Their argument highlights that the California Assault Weapons Control Act unfairly targets the guns that are currently on the market that are the most extensively used weaponry. Second Amendment challenge and legal strategy. When a court is faced with a blanket prohibition on the ownership of a particular type of firearm, the only question that should be asked is whether or not the firearm in question is normally owned by law-abiding persons for lawful purposes. The Supreme Court has made it very clear that this is the only question that should be asked. If the answer to this question is yes, then the restriction in question is illegal, since it is impossible for a state to prevent law-abiding citizens from holding something that the Constitution expressly grants them the right to keep. The answer to this question is unequivocally yes, as will be shown in the following explanation. They then add a powerful section emphasizing that this instance doesn't even require Bruen and the historical approach that is explained in Bruen. This section concludes with a strong emphasis. Taking a glance at the Supreme Court's decision in the case of Heller is all that is needed to fix this problem. Even if the court were to grant permission to the state in an attempt to justify the AWCA's rifle ban using Bruen's more nuanced approach, it would immediately become apparent that the state is unable to achieve its burden, even when held to the more relaxed standard. There is simply no precedent for outlawing firearms that are routinely possessed for authorized purposes.
Not because of functionality, not because of how fast a round comes out of the weapon, just because you don't like the way that they look.
Justice Scalia said it pretty well in D.C. versus Heller.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
Especially not only due to the fact that they possess features that boost their accuracy and control. This is a robust brief in support of striking down the California assault weapons legislation, which outlines in a clear and exact manner how the complete prohibition on widely owned rifles is a violation of the Second Amendment. This brief was written by the California Civil Liberties Union. It violates the Second Amendment's language, history, and tradition, and it does not adhere to either the Heller decision or the recent Bruen decision. This is a breach of all three. On September 9th, the court is going to hear all sides of the case regarding the motion for summary judgment, and then they are going to make a decision after that. At this point, the most intriguing question is whether or not the Rupp hearing, which is slated to take place on September 9 at the beginning of the following month, will actually take place before any decision is handed down by Judge Benitez. It is questionable at this time whether or not Rupp will in fact have a hearing on the request for summary judgment, because we are waiting for Judge Benitez to also rule on a motion for summary judgment in the Miller case. After that point, the waiting game will likely continue. Although hearings in Miller have already taken place, we are still awaiting a decision, so Miller is still officially in the lead. However, proceedings in Miller will shortly be interrupted, and at that point, both cases will be essentially at the same stage. That's all for this video, folks. See you next time.